So in researching on this, I thought, well, of course, we all understand that nations have sovereignty over their natural resources, but that's a relatively new concept. That's what surprised me. So under the Peace of Westphalia in 1648, nations did get sovereignty and territorial integrity. But that did not necessarily include natural resources, which was surprising. So the idea of having sovereignty over your own natural resources is actually a post-World War II concept, and it's more than that, it's post-colonial concept. And so if you keep in mind that these rules were developed for the post-colonial world, will help you understand some of the concepts that were enacted. So the idea, so the self-determination and resource sovereignty were part of the post-World War II regime that was set up. And there was a 1962 General Assembly resolution called Permanent Sovereignty over Natural Resources that recognized sovereignty over natural resources. It's probably customary law, but it may not be jus cogens. And that is a concept that says that it's such clear law that, every judge has to acknowledge that it exists. Whereas with customary law, there's a little bit of debate about whether, how applicable it is, what the customary law is. It's this concept of sovereignty over natural resources has been accepted enough that it is probably customary law and will be recognized by the ICJ. And so what does it mean? Well, this General Assembly resolution acknowledges the right of peoples to exercise sovereignty over their natural wealth and resources. That's the defined term. And it does refer to international law. The goals are to promote international cooperation for economic development of developing countries. So that post-colonial period, developing countries had natural resources. And so let's help them enter the real world and become independent successfully by letting them access and sell their own natural resources. It's based on principles of equality and self-determination, once again, post-colonial period, and promoting economic development. So you can see this theme running through here. But the natural resources are supposed to be used to benefit their peoples. And it does allow for expropriation. And if you think about the fact that, once again, we're in the post-colonial period, there were colonial parties that took advantage of natural resources in their territories. And so this resolution acknowledged the right of those former colonies to expropriate what had been natural resources that had been given to the colonial powers. So that was important for them. There is a potential conflict between the principle of the state's sovereignty over natural resources and the indigenous people's rights to natural resources, because the indigenous people predated the government that was later set up in the post-colonial period, if you think about that. So I think that conflict still goes on. And then there is limited sovereignty, of course, in shared natural resources. So what are the laws about transboundary shared fresh water? The first water treaty was in 2500 BCE for the Tigris. Since then, more than 3,600 water treaties have been entered into since AD 805. And there is, I think it's the University of Oregon that keeps a database of all of the water treaties in the world. It's a fascinating database for people who love that kind of thing. So you can see which treaties were enacted where and when and what they covered. And because there's such a long history of treaties and law and water, there is a big, large body of customary law principles. Now keep in mind that a lot of the law developed over land-based fresh water as opposed to groundwater, because people sort of took groundwater for granted. They weren't even aware that groundwater could be shared until relatively recently. And so, but you can see when someone's taking water out of your river, right? And so a lot of these principles developed because of land-based fresh water. So what are these principles? One is no significant harm to your neighbor. And so that means that you can't pollute, you can't dam, you can't do things that upstream that will hurt your downstream neighbor. So in a way, you could see that as favoring the downstream users because it limits the ability of the upstream users to do whatever they want to do with that water. So it really tries to protect the downstream users. But you have to have something for the upstream users too, because You know, the water hits them first. So that concept is called equitable and reasonable use. And what that means is you can use the water, but it has to be reasonable. You can't take more than you really need because you have to think about these downstream users as well. And also, the customary law now seems to have developed to include data sharing, information sharing, cooperation on using the shared natural resource, prior notification of significant acts. So if you're going to put in a dam and you're upstream and it's going to impact the downstream users, of course you have to let them know. So that's a significant act. And then protecting the ecosystem is a more recent principle of transboundary freshwater. There are two existing global agreements. One is the 1992 UNECE Water Convention. It has 55 parties, and the ECE is the Economic Commission for Europe, but it includes other than European countries as parties. And a number of years ago, it was opened up to all UN nations. So now all UN nations can join it, and they have been. So it has 55 parties, which is many fewer than UNCLOS, for example, which has 170. So these treaties have not yet fully been embraced, but we're on our way. That treaty favors the no significant harm principle. So in a way, it favors those downstream users, whereas and it does include confined aquifers, which is interesting. So it was very forward-thinking in that way, even in 1992. In 1997, there was the UN Watercourses Convention, and they sound very similar, but they're not the same. And that one was always open to all UN member states, and that one only has 40 parties. And so that one has not been as well accepted as the UNECE. One reason for the UNECE Water Convention being more accepted is that a lot of the European countries, there are a number of them, embraced it. So that already led to having a number of parties. But the UN Watercourses Convention favors equitable and reasonable utilization upstream. So what does that mean? It means that it favors using water for development. So if you think about the UN Convention as favoring development by favoring equitable and reasonable use upstream, and the UNECE Water Convention favoring no significant harm to protect the downstream users, you can see there's a little bit of a conflict between them, but parties are encouraged to join both because it's seen as full protection. But that one does not include, the UN Watercourses Convention does not include confined aquifers, which is one big limitation. And so if you have a confined aquifer, then that convention doesn't really apply to you, that resource. What are not in force are a couple of groundwater provisions. The 2008 UN draft articles on the law of transboundary aquifers, that was introduced in 2008. It has not come into force, although it was a major influence in the treaty for the Guarani Aquifer. But one of the reasons that it wasn't widely accepted is that it gives sovereignty. And nations objected to giving sovereignty to anyone over a transboundary aquifer. The UNECE model provisions on transboundary groundwaters, by definition, are just model provisions. It's not meant to be a treaty, but it is meant to be guidance. So how should these principles and treaties impact transboundary groundwater? I'm sure you all know this, but transboundary groundwater is groundwater lying under one or more states. Or it could be groundwater in one state with a recharge in another state. Or it could be groundwater in one state with a discharge in another state. And according to EGRAC, which tries to produce a catalog of all of the transboundary aquifers, there are more than 600 that have been identified, and they keep a database that you can access. With these images, I'm trying to give you ideas of some of the better-known transboundary aquifers. So this one is sort of a special case. This is the one between France and Switzerland. And basically, it allows for storage of water in Switzerland that France can then utilize by helping to pay for the expenses of the whole process of maintaining that aquifer. And it's worked very well for quite a long time, for decades, and they've just renewed it. I guess they renewed it, about 5 years ago, because it's just working so well. There are very, very few treaties on transboundary groundwater. One is the one I just told you about, and so that one, 1977, renewed in 2008. There's the Nubian sandstone aquifer system that has 4 countries that share a big aquifer in northern Africa, and so there have been 3 agreements about that, as you can see. There's the northwestern Sahara aquifer system, 3 countries sharing that. Notice that Egypt is a party to both, so Egypt shares 2 transboundary aquifers. There's the Guarani aquifer system. That's the one that pretty much followed the draft aquifer articles that were produced by the UN, and it even references them in the prologue to the treaty. And that one just came into force in 2020. And then there's the Al-Sag, Al-Disi aquifer system between Jordan and Saudi Arabia. That's a relatively recent one, only 10 years, that they've reached an agreement on that. There's another agreement for the, and I wouldn't even try to pronounce all of these names, but the Ilimeden. And you can see there are a lot of parties to that. There are, 7 countries that share that aquifer system. It's actually a system of a couple of aquifers that are interconnected. And their 2014 agreement only provides for a consultation mechanism. Most of the ones that have been, most of the treaties that have been enacted were facilitated by the Global Environment Facility, particularly the Guarani Aquifer Agreement, which meant that they had expert advice throughout the treaty process. So what is the customary practice, if there is any? The common provisions in these treaties for land-based transboundary groundwater are data sharing and information, cooperation, and prior notification. If you'll recall, those were also part of the customary law for land-based water. But they don't include reasonable, equitable, sustainable use, no significant harm, or environmental protection. So that's very interesting. And so one of the issues will be, as we look at formulating recommendations for usage of transboundary offshore freshened groundwater, do we include reasonable and equitable use? Do we include no significant harm, environmental protection? And those are decisions that are going to have to be made. There's not enough common practice in transboundary groundwater for us to be able to say that there's really any customary law at all. So we get to create it. We get to create law if we want to. And then this is the Nubian sandstone aquifer. I find this to be really interesting, because there's this enormous aquifer filled with tons and tons of water in the desert. How did that happen? Well, the way it happened is that in millennia ago, this was a very water-rich area. It was almost tropical, all of northern Africa. And the water got emplaced many, many years ago. And it was still there. And so, but it could be, it doesn't recharge, but it's not confined. And so what prevents it from recharging, because it's considered to be what they used to call a fossil aquifer, non-recharging, what prevents it is that the water, there's no confining layer, but the water will evaporate before it soaks through the sand and recharges the aquifer. And so basically with these non-recharging aquifers, any use is mining the resource. And it will be the same thing with offshore freshened groundwater, because it's not, unless it's connected to land and recharging there, then any use of the offshore freshened groundwater will be mining it because it won't recharge. And so that, for me, that brings along a responsibility to protect the resource. What are emerging trends on sharing water? There's the human right to water, so you have to leave enough water for the humans. But you also have to take into account that there are other species besides humans that rely on water. So that's interspecies equity, humans and other species. Intergenerational equity. If you're mining the water, and there are a lot of these non-renewable groundwater reserves that are being depleted, I'm sure we all have our list of our favorites, then what does that mean for future generations? So we take it all for this generation, then what's left for future generations? So we have to think about other species and future generations of our own and other species. And benefit sharing, which is mentioned in the UN Convention on the Law of the Sea and the Convention on Biological Diversity, and that is, if you have water, then maybe you need to share the benefits of that water or share the benefits of other resources. And my LLM thesis was entitled Fossil Aquifers, a Common Heritage of Mankind, because I was promoting benefit sharing of fossil aquifers that have not yet been discovered. Like the ones that have been discovered already, they're already in use, but for the future ones, then let's consider sharing them on an as-needed basis. Of course, that idea will never take off, but still, maybe we need to start thinking that way. And as I just said, offshore aquifers are an opportunity for new paradigms to be created that maybe are more equitable. So these are the questions that I'd like for us to discuss. Should land-based treaties and principles and practices for shared water apply to offshore freshened groundwater? Should land-based treaties, principles, and practices for shared groundwater apply to offshore freshened groundwater? If so, which principles should apply? And if not, then what other principles can we think of to recommend for sharing of offshore freshened groundwater? And these are images of two more of the aquifers that have treaties. And it's pretty easy to see the DC aquifer. It's down here, shared by Israel and Jordan. And then over here is that Illumidan aquifer system. Look at that. Look how many countries. And it's several aquifers. You can see they're sort of interrelated and overlapping because they're at different levels within that area of Africa. And so how do you get all these countries to agree on how to utilize the water in a water-scarce area? So it's no wonder that all they have right now is a consultative mechanism just to talk. Let's just talk for a while, which is what they've been doing. And I think that's the end of my presentation. Thank you for your attention.